Today's topic is about corporate practice in general, and you won't believe that I have seen people heavily misguided about what corporate practice entails, and even specialized programs such as LLMs have made people do financial diligence. I mean, asking people what is the scope of the company's financial progress as an assignment while teaching them what company law or corporate law. I mean, trying to teach them company law and or make them experts in company law. So, first of all, to break the myth and to start with the presentation, I would like to say that whatever you read and study in law school or even specialized courses like LLMs is very different from what we do actually in corporate practice in reality. Now, to begin with, it is not just about company law. First of all, corporate practice is not about that. There is much more to it, and Nabarun and I will be delving deeper into it. But things have become super specialized. Company law is just a part of the entire transaction, and that also it is mainly the procedure. What has happened is, first of all, corporate practice itself has increased into different facets. It is There are specializations in the form of practice area itself. Like for example, I am doing PEVC, okay, and Nabarun is doing mergers and acquisitions. And then there are practice areas which deal only with competition law, only with SEBI practice and corporate governance, listed companies. So it is like it's from a minuscule understanding of what corporate law is. It has blown up to such a proportion that now there are specializations, and there are specialization within the specializations. So for example, in PVC also, for example, I am doing investment transactions. In investment transaction also, people have specialized in tech. So they do investment only in tech industries or asset light industries. Then there are specialization in online gaming, name it, and cryptocurrency, blockchain, consumer protection for that matter. It's a plethora of things, and a number of laws get covered. But having said that, there's nothing to worry about it. I will tell you how to approach it rather than getting into the details and reading out sections to you. Okay, so as I was saying, the first we'll discuss the broad practice areas that are there in the market, and laws for each of them is different. Okay, so for corporate commercials, it is generally company law, but other than that, there are other corporate laws such as the securities law, capital markets, whereas is strictly about SEBI and SEBI driven laws. And from my experience, I've seen when I've asked someone to research about an unlisted company, people have got me research from SEBI LODR or SEBI ICDR. Now you have to understand, company law deals with broad spectrum of companies, which includes listed and unlisted. It is only when you deal with listed companies that you get into the SEBI driven laws. Capital market as a practice deals specifically with SEBI driven laws. And if you're, mainly those, and the best part about SEBI driven laws is that it is easily available, the latest updated version, and you can just go to the SEBI website and read up on acts, regulations, and always be updated about it, because laws are changing very fast. Thankfully, as I was saying, that a lot of it is easily available nowadays. So for example, when it comes to Reserve Bank of India driven laws, RBI laws and FEMA, it is easily available on the RBI website, updated versions with proper red lines of showing what changes and amendments were brought in at what point of time. Similarly, for SEBI also, SEBI, there is a separate in the SEBI website itself. It's easily available, accessible to all. You can just go to the SEBI website, pick it up, and read the latest regulation as on date. And capital markets, I'm telling you, rather than the jurisprudence, it is more important what is written in the law. Obviously, you need to have your basics clear when you are in your practice area, in a particular practice area. But what is the current status of the law is very important to understand. Then there is competition law, which only deals with competition act. There is hardly any other avenues we can venture into while if you're practicing competition law. It is just mostly Companies Act and the Competition Act. That's it. Then banking and finance is again a huge arena. It includes banking laws, and it includes transactions such as debt transactions and mortgaging of assets and that kind of transaction. Then there is restructuring and insolvency, which is obviously about which is mostly Companies Act driven, which you'll read up in law school also. And this is what exactly what most of us has been taught about debt restructuring. And then there is corporate restructuring. Mergers and acquisition is a court driven procedure. There are a certain number of sections in the Companies Act which become very relevant for you, and you need to know them by heart. That is the section 230 to 234. Investment funds and asset management is again an emerging thing, which is basically SEBI has started recently to regulate heavily these fund structures. Okay, so say for example mutual funds or AIFs, which are nothing but a pool of investment. Okay, and high net individuals or people with money basically invest in those pools, and then those pools appoint qualified personnels to guide the fund as to where the investment will happen. So this I'm talking about is happening at the fund level where the fund is getting created. Now this is a different level of compliance requirement under SEBI. There are time to time you have to give updates on the fund's progress. Then you have to file statements with the Securities Exchange Board of India and give them update about the investment funds. So that is a different. Then there are agreements between the fund and the investment manager. Then there are agreements between the investors and the fund. So it's a different level of practice area altogether. Then there is taxation practice, which typically deals with the tax laws, and you become super specialized in that. Then dispute resolution is another arena, which is somewhat venturing into litigation. And mostly the litigators have only started. Litigators in corporate have started or have ventured into dispute resolution. Then there is employment, labor, and employment laws are typically what we know as like those EPF, ESIC, then contract labor, shops and establishment. You will get to know about it when you deep dive into it. But it is a practice area in itself, and once you become super specialized, you have to keep a tap of it. The problem with employment and labor laws is that not everything is easily available. There's constant research, and you have to know a lot of jurisprudence. And there is a huge scope for opinion and advisories. Then there is energy, infrastructure, and resources. Energy law is a different ballgame altogether, heavily regulated by the ministries. Then there is environmental law. This is again an emerging practice area. Then there is estate planning and private clients. Again, these are very high billing clients, but you have to be superbly clear with your understanding of the law. And this doesn't include any particular facet of law. It can include anything and everything under the sun. Then there is regulatory practice, which basically talks about RBI related laws, and then SEBI related laws, and then other compliance requirement. Then there is intellectual property, which basically deals with specifically the intellectual property laws, which most of it is taught in law schools, thankfully. Privacy and data protection is again something very emerging. It typically deals with the IT Act and the data privacy laws, but there is also an angle of constitutional law to it. So you have to know both, basically have your basics of constitution clear, and at the same time, also because there is not much jurisprudence in this area, you have to mainly rely on these case laws, age-old case laws, and constitutional law basics. Then there is real estate. Real estate again has like what we understood as real estate practice has changed like mammoth. It is now a lot more transaction driven rather than just doing title search about lands and finding out whether the title is clear or not. There are joint development agreements at massive scales which are executed. There are entities which are floated to collect funds from investors and then create a particular project. White collar crime like data privacy is also an emerging practice area, and people have started specializing in this. This mainly deals with all kinds of white collar crimes, and like there is Prevention of Corruption Act. Then there are foreign in this scenario. Even you have to be savvy about the foreign corrupt. I mean the FCPI, the foreign anti-corruption laws as well, especially the US one, because most of the companies who are in US have to ensure that wherever they invest in, or wherever whatever they deal, whoever they're dealing with, also is compliant with the US anti-corruption laws. And then there is private equity, which I deal with, which specifically deals with a particular section, I mean portion of company law, which deals with issuance and allotment of shares. What happens in this kind of transaction is basically there are investors, these investment funds which we discussed before. Once they are formed, they start investing in companies in which they think there are potentials, and once they start doing that, they ensure that what they're investing is also secured, I mean not only financially but also legally. So this is what private equity and venture capital is. Nothing but the investors investing in companies, mostly startups. And I mean again, it can grow up, and as and when the company grows, there are levels of funding which happens. Like as Komal was just saying, Nabarun did a funding in Rapido, which is a Series D round. Now the company has grown big, and now it is not no longer a small term funding. It is just it is, I think, the fifth round of funding which is happening. So that is what entails private equity practice. And last is technology and telecommunication. Again, this is corollary to privacy protection. Many people who used to do tech are doing privacy, who used to do privacy are doing tech. Again, this entails mainly IT Act. Now, this area, privacy and tech, has become very, very active, especially with MITI releasing, I mean, the Ministry of Information Technology releasing circulars every other day, certain increasing its scope and capacity, in which earlier was a very silent body. So that's about all the practice areas that is there. I have briefly touched upon all of this. Now Varun will talk about it in details. Now coming to the types of deals. Okay, pardon us, but we'll be dealing with the practice areas that we specifically delve in on a regular day-to-day basis. We will not be able to talk about mergers in details, although we can briefly touch upon smaller doubts if you have. But majorly, we'll be talking about the practice areas on which we deal on day-to-day basis, because we are in a better position to talk about that. So first is transactions. Transactions, I was explaining, is basically where companies are either funded, or one company acquires the another, or there is a merger happens which is not court driven. So first of all, let me deal with the private equity transactions. Okay, private equity transactions are basically nothing but investors investing in an entity. The main documentation, and it mainly revolves around issuance of shares under Companies Act, which is dealt with Section 42, and transfer of shares, which is Section 64. You have to by heart know of these particular sections when you're dealing with it, and obviously the rules framed thereunder. So once you have read the law, now it comes to the documents that are involved. In a private equity transaction, it is mainly an share subscription agreement, pursuant to which shares are subscribed, and the other one is a share purchase agreement, where new investors come in and they purchase the shares of the existing investors, a few of the existing investors. Now that is about private equity transactions. Next is acquisitions. Acquisition is similarly, there is an SPA only included, share purchase agreement is only executed, and the entire shareholding of the entity, of the target entity, gets subsumed by the investor. That is acquisitions. Then there is mergers. Mergers is mostly code driven. Okay, and basically the entities approach the court with a memorandum saying that this is how we want to proceed with the merger. This is the date on which we want the entities to become one single entity, either one entity subsumed by the other or both coexist at the same time, depending on the type of the transaction. Then there is advisories. Advisories is basically once you are super specialized in a particular field, not only corporate law, it can be corporate plus, say, information technology, it can be corporate plus data privacy, it can be corporate plus as simple things as online gaming, or you are basically, once you're super specialized, people will come to you for different sorts of advisories. And also about generally about corporate law, sometimes clients will approach you for your opinion on a particular niche area of corporate law, and this is where your expertise come in. This is where you deep dive into the sections, the interpretation of the sections, and see if an element of your action is doable or not doable. Third is external engagements. External engagements is basically where a foreign counsel approaches you for a larger transaction that is happening, say at an international level where multiple companies are getting acquired. And the other form of external engagement is where you get seconded to another law firm, and for a particular period of time where they need specific practice area expertise from India. Now coming to the brief overview of how the transactions take place. First is identification of the target. Now, be it any transaction, the investor or the larger entity which is more bullish, which is trying to acquire or merge, which basically will identify a target. Now, most of the times what happens is when it comes to smaller entities, it is generally the targets who approach for funding and all. But in case of larger transactions, it is more of a mutual understanding that people approach with each other and they identify the target. Now, once the target is identified, a basic diligence is done. Basic diligence in the sense, how's the company doing financially? Obviously, the lawyers don't get into it, but the financial team or the iBankers or say chartered accountants in case of small companies, they do a basic research on how the target is. How the target is doing. Does it have potential or not? Is there a market? So there are specific entities. Don't get misguided. This is not a lawyer's job. It is more of a job of an MBA who sees the market potential of that particular entity. Then a term sheet is drawn out. Now, this is where the lawyers step in. So what will happen is the promoters approach you. Either from both sides or one of the promoters will approach you and say that, listen, we are, or not only just promoters, the investors. When I'm saying promoters, I mean the leads of both the entities will approach you and say that, see, we have this transaction planned. Now there's a small step which is in between these two, that is called structuring. I'll come to it. But they will approach you and ask you to draw up a term sheet. The term sheet is nothing but a broad contours of your understanding of how the transaction will be. Before we before lawyers get into the drafting of the term sheet, they engage in something called structuring. Structuring is nothing but seeing the way the transaction is structured is legally sound or not. So, for example, investment is coming from outside India, and investment is happening at India level in an entity which is doing XYZ business. Now, as lawyers, we will first see if at all, as per the NDI rules, non-debt instrument rules under FEMA, we can actually do that transaction, or do we need a government approval for that? Or is there a way to bypass that government approval by creating a layer? Now, that is what is basic understanding of structuring is. In layman's term, this is the best understanding. So we see whether it is legally sound or not. Now, there are similarly, when an Indian entity is investing abroad, it is mostly the overseas direct investment rules, regulations which come into the picture. Now, quite recently, a lot of changes has happened in this front. So, for example, non-debt instrument rules, that is the FDI laws, and the FDI policy is as latest as 2019. The recent ODI rules was introduced a month back. So you see, these are very fast changing, and there's a lot of scope, and so you have to constantly update yourself. Quite recently, one of the interns, I asked him to find to research and write a paragraph about the FDI laws, and he wrote about TISPRO, which was repealed as far as 2018. So that you will have to be careful about. See, some of the laws you cannot compromise on being updated on. One is Companies Act. When you're dealing with private equity, venture capital kind of transactions, you cannot compromise on reading up and being updated on these laws. First is that particular chapter of Companies Act which deals with private placement and transfer of shares. You will have to be updated about it. Then second comes is the FDI laws. FDI laws are changing every other day. Sometime quite a few years ago, there was a government body called DIPP that was abolished and a new entity came into the picture. Then the NDI rules came into the picture. Once the NDI rules came in and the pandemic hit, there's something like something called a PN3 notification came in, which is basically saying that entities which share a land border with India will have to come through government approval route only, and there are certain restrictions to it. So that again, that is a further layer got added to the NDI rules. Then again, pursuant to that, subsequent changes happened in the Companies Act. Similarly, ODI laws also are kind of like now synced with the FDI laws, and there an interplay can be seen between the two laws. So laws have become much more simpler, easily accessible. You just have to go online and search for it, and you can read it up line by line, and that is the best way you can read company law or money. Make yourself adept with this corporate practice area. Few laws you should cover, I told you. Apart from that, if you are venturing into a listed company, you should be well aware about SEBI listing obligations and disclosure requirement, that law, and the issuance related SEBI ICDR. These are a must know when you are dealing with these practice areas. These should be bread and butter. So one of my mentors told me that he was carrying a book of CPC in his pocket, and his mentor told him that, if it is your practice area, the manual should not be in your pocket, it should be in your head. So you have to be that well aware about the laws that you're dealing with once you have decided on what you want to do in your career. Achha, having said that, chalo, enough of Gyan, but having said that, now we'll see, we draw up a term sheet. This is a typical acquisition transaction where one entity is getting acquired by the another entity. So there is an entity called, say, Acquirer Limited. Okay, and that is entity is acquiring, say, a target entity called the Target Limited, and there are two promoters. Mostly what happens is this term sheet is non-binding. I mean, there is apart from the few things, non-binding in the sense this cannot be enforced in a court of law. The reason being, even both the parties have very limited understanding of each other, right? The investor does not completely know what the target entity is fully compliant or not, or is what the target entity is financially capable or not. They have a brief understanding, so they want to keep it loose, and that's why the term sheet is mostly, in most of the cases, it's a non-binding term sheet always, barring a few sections. That being, and I'll come to that. So first and important is the parties. Who are the parties to the transaction? There is the acquirer, there is a target, there are existing investors. If it is an old company, if it is a new company, this is not there. This may be the first investor, and obviously there are two promoters. Let's call them MRDS or whatever. Now the target is then the basic structure of the target is set out. The business of the target entity and the proposed transaction is set out. The proposed transaction will briefly describe what the transaction is about. Is it an acquisition? Is it a merger? Is it an investment transaction? What kind of investment? How many investment layers of investment will be there? Will it happen in one go or will it happen in tranches? This is what basically the proposed transaction section will deal about. Then obviously comes the condition precedent part. Now, this is only the condition precedent is very at a preliminary stage, where investors only set out those things that they want the target entity to rectify before the diligence has started. This will be very limited and common understanding. I mean, for example, execution of transaction documents. Now that is an absolute prerequisite, that a diligence is not required for that. And by diligence, I mean doing a research on that particular entity. This condition precedent will be basic and mostly it is standard form, which the investor or the acquirer wants the target entity to fulfill before they actually do the investment. That is which we typically call as closing. Then there is a condition subsequent, if at all something is required. Say after the transaction is done, you know what filings will be required, that you can put at this stage only. You don't need to wait for the diligence to happen. And again, as I said, it's non-binding. If something changes in the transaction, it will not impact the term sheet. Next is the transaction documents. Transaction documents, you write down what all transaction. For example, in PEVC, I told you, it is in private equity and venture capital, it is mostly the share subscription agreement, which deals with issuance of shares, or it is the share purchase agreement, which deals with acquiring or transfer of the shares. It can be a combination of both also, where you are subscribing to shares and at the same time you're also purchasing of share from few of the shareholders. So it can be an SPSA as well. So you write down. And one more thing, unless it is a complete acquisition, there is another document which is executed, which is called the shareholders agreement. It is very important that you know about shareholders agreement as well. It sets out the rights of the investor and other shareholders and how they will interplay with each other, like what kind of board rights the investor will have, what kind of information rights the investor will have, whether there is a restriction on the promoter to dispose of the shares, whether the investor can freely dispose. All these restrictions and rights of the shareholders, once they become a shareholder of the company, is set out in the shareholders agreement. And that shareholders agreement is ultimately restated and formed into the articles. So these will form a part of your transaction documents. It is either SPSA, SSA, or a shareholders SHA, which is the shareholders agreement. And then there is SPS, SPA, SSA, SHA, and mainly also one more element is there, that if you want to bind the promoter with an employment agreement to so that so when you're investing in when an investor is investing in an entity, they will have to be sure that the promoter does not jump ship and scoot or open another entity. So they put a lot of restrictions on the promoters, that you cannot leave the company. If you leave the company, your shares will be forfeited. Then your employment cannot be terminated. Just like they have to be invested in the company, because I am investing in the company, relying that on the fact that you will be invested in the company. So if you are not invested, what is the use of me investing in the company? So all this are captured in the employment agreement. So this is basically what is captured in the representations and warranties are again very briefly captured at the term sheet stage. There's nothing much which is stated, but generally the authority capacity of the entities to enter into a contract is something which is the basic fundamental representations is captured. Then there is standstill obligation. Okay, standstill obligation and no shop clauses. Because in the term sheet stage, what happens is some of the promoters go, I mean, especially you have seen it at a very companies which are at the nation stage, when they start receiving funding or they get offers for funding, they think no end of themselves. What they do is they will take an offer from one investor and they will go around the market saying that I'm getting investment from XYZ investor. Do you want to invest? Do you want to invest? So what, in order to protect the interest of the initial investor who have approached or who have agreed to fund, what they do is they put some sort of standstill obligation. Say, listen, till we are completing the transaction, you will not sell your entity to XYZ person, or you will not sell your entity to anyone, or you will not go for further funding until my funding is completely completed. So this is what they mean by the standstill obligation, and this is one of the provisions which is kept binding specifically in the term sheet. Board composition again will be acting as a guide for you to draft the shareholders agreement as to what the board rights of the investor will be or the acquirer will be. In a complete acquisition, remember, these rights does not matter because the entity completely becomes your own. Then you can frame your own board rights. Then these kind of clauses will not come into the picture. What board rights you will have after you have acquired the entity, because it's like your entity only. But in case of an investment transaction where there are other investors, where there is promoters, and you are also the investor representing the investor, you have to ensure that your rights play out properly. Next is preemptive right. Preemptive right is basically your further right to subscribe to more shares in the company. Tag along is basically nothing, but if someone is jumping ship, the promoter, you have the right to tag along. And also there is something called a drag along right, which Nabarun will discuss in detail. But anyways, drag along is nothing but you have the right to drag the promoter. Then there is anti-dilution right, where your shareholding cannot be diluted. There are affirmative voters which says that the company cannot take XYZ decisions without your approval. Then there is the validity of the term sheet. This becomes very important, and this is the most debated part of the term sheet, which says that the term sheet will be valid up till XYZ date. And most of the times I've seen that the transaction execution, I mean, the documents are not yet finalized up to that date, and there is an extension, there is a further extension which keeps on happening of the validity of the term sheet. The term sheet is valid only up till the documents, the main document, SSS, PSHA, and employment agreements or the disclosure letter is finalized and signed by the parties. Exclusivity is basically deal with us until the transaction is completed. I mean, that is how you put it. Then there is the governing law. Governing law is another portion which, and dispute resolution is the another aspect which is kept as binding, because God forbid something goes wrong, you should have that avenue open. Then it should not be the case key your term sheet was not binding, so the dispute resolution clause is also not binding. That shouldn't happen. Confidentiality is also kept as non as binding, and cost and expenses also, because both the parties, be it acquirer or be it the acquired, both incur some sort of expenses, so they keep it binding. And confidentiality is obviously binding because sometimes these funds are very savvy, I mean very finicky about or funds or say listed companies are very cautious about data of what they're trying to do getting leaked in the market. Obviously with listed companies there is a price sensitive information issue involved, so they have to be doubly careful. But otherwise also, in case of funds also, they don't want their strategy to be disclosed that way ahead when before the transaction is completed. So as you can see, I have there's a clause called binding nature which sets out certain which is binding. Then obviously there's notice clause and basics. I mean there's a signature page. And then the diligence happens. Diligence is again an important stage of the transaction. Basically, you deep dive into the entity's compliances. What happens is the first stage of the diligence is you send in something called an initial requisition list. Initial requisition list basically sets out a set of questions which is all encompassing, basically asking every relevant questions which are important from a diligence point of view. It is divided in sections. First is obviously the corporate section, where you'd ask about the incorporation of the company, the shareholding pattern, the recent constitutional documents of the company, and if there is share transfer happened, if any are FEMA filings, Foreign Exchange Management Act related filings which has been made, the ROC filings which has been made, the minutes maintained by the company. So something which is applicable for every kind of company. Then you come to there are other sections also. There is employment, there is licenses and permissions, basically dealing with the licenses, asking about the licenses that are there with the company. Once you have asked this question, the target entity response gives you a response either in the form of a document where they say, see, this is the document, or they will say, we don't have that document, we have not complied with it, and which becomes your issue in the due diligence. And the third option is they have is that something which is not applicable to them. For example, it has not received any kind of foreign investment. It will not have foreign investment related filings. So the target comes back with the responses. Now what happens is, please try and understand, due diligence is not about capturing data. People are not interested in knowing how lengthily or how mammothly you have captured a particular document. It is not about that. It is only and only about issues in that document. And how do you identify issues? You have to know about the transaction. So most of the time I've seen intern write, people who have done internships have written in their CV that I have done a due diligence. Now when I ask them, Acha, what is the what kind of diligence did you do? And then they go blank, fail to answer or identify the nature of diligence. See, diligence for every transaction is different. For a listed company transaction which is floating its shares in the market, which is issuing new shares, is very different from a diligence which is done by a entity, which is the way you will identify issues only different. For example, over there, you will only diligence about in case of a listed company, you will identify the license and permissions not taken or the pitfalls. But in case of an investment transaction, you'll also see the contracts and see if there is a change of control provision or not, if there is a restriction on the transfer of shares in the existing shareholders agreement or not. The perspective with which you approach the documents only will change depending on the nature of the transaction. So before you do a diligence, it always, even if you're in an internship or you're in the year one of your career, ask what the diligence is about. Is it an investment transaction? If it is an investment transaction, is a change of control happening? Okay, because for example, there are licenses which will require you to go to the authorities and ask for permission if there is a change of control. So sometimes the transaction, the investment is so small, there is no change of control happening. That issue becomes irrelevant in that case. But if it's a major acquisition or transfer of the company, then in that case, change of ownership, control, those provisions you'll have to look for those provisions in the documents. And that is how you will have to approach the documents. Next, there is valuation, which is parallelly done by the iBankers or basically the MBA guys will do it. It is not our job to delve into valuation. Yeah, but you'll have to know certain provisions regarding valuations. For example, in FEMA, there is a set criteria for valuations. I mean, it has to come from a SEBI registered merchant banker or a person who has practiced accountancy for say 3 years. Then Companies Act, it is different. Then there is negotiation of the document, which is where the lawyers step in and they fight, move from both the sides. Sometimes as an acquirer, you have an upper hand when it is a small company and you make the promoter sign literally on the dotted line. And it doesn't, they don't really have a say. They engage lawyers to have little bit of saving. But most of the time I have seen that they hardly have a scope to argue and negotiate their position. But things change when it is a 50-50 JV entity, where both the parties they have an equal say. Like the term sheet that I was showing you, both the parties were like very strong, and both of them. So there, the negotiation becomes smaller, very strong, and very granular. Gets into the minute details of each and everything, as minute as the day on which the transaction money will flow in, and to the exact board rights, exact affirmative vote rights, and how they will interplay. Is there any conflicting provision or not? It goes very deep. Okay, then there is transaction documents, which is basically once the transaction is completed. Then there is condition precedent. Condition precedent is nothing but once a diligence on an entity has been completed, we as lawyers identify, and also financial diligence people and tax diligence people, tax diligence guys also, they will find issues in the target entity and will ask the target entity to rectify that. Those becomes your CP. Once your CPs are completed, then comes the provision of closing. Closing is nothing but the actual happening of the transaction, where money comes in the company and the shares are issued or the shares are transferred. So that is basically what we understand as closing. And then there is post-closing actions and integration. So if it is a merger, there's an integration happening where both the companies merge, their accounts become one. If it is a investment transaction, the articles are restated and filings are made in PAS 3. And if it is an acquisition transaction, then it is the shares transfers are taken on record. So this is what we understand as the post-closing. Now over to Nabarun.
Keeping in mind that majority of our audience are law students and basically junior advocates and the time allotted to us, I'll be keeping the discussion at a very high level without getting into too many details. Now, without much ado, I will move towards the first point of the discussion, which is essentially the types of clients. Before I move into that, just wanted to emphasize on the fact that corporate law is such a practice in that if you work in this area of law, no doors will be closed to you. No two corporate transactions or deals are the same. The difference can depend on various factors such as the type of industry, whether it involves single or multi-market businesses, and the size of companies involved. The practice of corporate law involves general corporate matters, as discussed by Supallab, such as incorporation of the company, directors and shareholders' rights, the articles of association, board meetings, secretarial matters, listing, delisting of companies, etc. Now, usually the type of clients that we deal in such deals and advisories are basically can be divided into 5 or 6 broad points. I have just listed out 5 very high level sort of points. First is domestic and foreign clients, which can include Indian entities as well as foreign entities or individuals. The next is the individual or the business owners, or as we call it in our corporate jargon as promoters. The next is company management or GC, which is actually the general counsel. So often or not, we'll have general counsels of companies in India and abroad come to us with specific doubts, as in so for example, what could be the maximum remuneration of a director? Can it exceed, say, any level, or has to be restricted? So there is a particular section under Companies Act, Section 197, which particularly deals with this. The next point is on financial institutions. Now, you would have seen various deals where we've advised banks, World Bank, international financial corporations in their deals in India as well as abroad. And the next is on foreign firms. So a lot of foreign law firms, Magic Circle law firms, a lot of big 4 audit firms, they more often than not reach out to us with respect to their transactions. And, we do the India leg of the deal. The one other client that I haven't mentioned is basically government and regulatory bodies, and we also advise governments and regulatory bodies such as SEBI, etc., to on various aspects of law. That is essentially covering what are the types of clients that we usually deal with on a day-to-day basis. Now, basically moving on to the basics of and the structuring of transactions. Now, usually it can be put into 3 brackets. First, as discussed by Supallab, it's merger, demerger, which is, again, it's a code-driven process. Currently, it's under the NCLT, and, it ranges from sections 230 to 234 of the Companies Act. Next is acquisitions. Now, this can be again divided into 2 parts. One is business transfer, one is share purchase or issuance. Business transfers can again be divided into 2 parts, slump sale or asset sale. The difference between, the slump sale and asset sale is that slump sale, you basically buy the business as a whole, as an undertaking, an ongoing concern. And asset sale is basically, you just cherry pick the assets. So you can just buy the, say, for example, plant and machinery of the company, and you're not bothered with anything else. For share purchase and issuances, usually in share purchase, you have a shareholder and you are an investor and you want to, say, buy the company. So basically you'll just buy the shares from the shareholders. And in case of issuance, the company issues fresh shares. The difference between purchase and issuance on a pragmatic level is that when you purchase shares from a individual or, say, a company, the money actually flows to the person who holds the share. But in case of issuance, the money will flow directly to the company. That is primarily the main difference. So that essentially is, what the key transaction structures that we deal on a day-to-day basis. Now, as discussed by Supallab, I'll just, briefly touch upon the points that he discussed. Now, first point being on the identification of the target. Now, as rightly pointed out by him, it's basically for the business guys, although, we have situations where, the business guys would have lawyers in the room discussing with potential, startups or businesses, where, the entire business model, whether it's legal or illegal, and whether it can be done. So in one of my transactions, we had basically a company which dealt with fertility clinics, and it turned out that entire business model was illegal. So what they were doing is basically, see, in India, you cannot determine the sex of a child, right? But what this company was doing, they were basically, engaging with their clients, saying, okay, if you want a male child, we have, hospitals connections in Dubai, and we can get you a male child. So, ultimately, this what you can't do directly, you can't do indirectly. That's one of the basic principles of law. And ultimately, what happened? The entire IT, sector, the entire IT authorities had conducted a sting operation where they found out this, and they had this raid completely done, and the company has now been shut down. The promoters are in jail. So that's something that more often than not, why you should involve your lawyers at the very beginning of the stage. Next is on the term sheet. As well, very well pointed out by Supallab, we discussed all the relevant provisions. So I won't go into much details with respect to that. moving on to due diligence. Now, what is the principle of due diligence? Just let me put it in very layman terms. So say I want to invest 100 million in one company. I see this company is doing good, but I invest my money and tomorrow I find out that there's no license, or say the business model is completely legal. So my 100 million goes down the drain, and I don't want that. So this entire, the principle of caveat emptor, which is buyer beware, is very important, and which is the genesis of the due diligence process. Now, what it usually entails is, and as pointed out by Supallab, is that we're not making summaries of documents here. It's essentially reviewing those documents, identifying the issues and the risks. And once they have identified, now we look, how to address them. And the way to do about it is basically we link those actions in the definitive documents or the transaction documents. Now, how do we link them? So it can be part of the valuation. So say, for example, there are major red flags. Say the business model is illegal. So now say I was valuing a company as a business person, say 100 million, but because the business model is not say illegal, say irregular. So I'll probably now value the company at 50 million. So I can adjust the valuation. Now moving on, the other two is basically business valuation, which essentially is, as pointed out by Supallab again, he said that this done by the business guy usually consists of a merchant banker or the investor himself, where basically they will assign a value based on what this company could be, right? What is my perception of this company? What is the value of the company? And accordingly, I will value the company. The next part is the legal requirements of valuation. Now, there are broadly 3 laws which require you to have a valuation report. One is Income Tax Act. The second is Companies Act. And the third is the Foreign Exchange Management Act. Now, all the point here is basically why we have a valuation report is to determine the fair value of the company, right? And there are a lot of ways of going about it. There are certain principles set out how to come up with the valuation, and also the fact that who can basically provide the report. So in Income Tax Act is usually merchant bankers can make a report under Section 56 of the Income Tax Act, and Companies Act is usually a chartered accountant. Under FEMA, I could be a merchant banker, SEBI registered merchant banker, could be a cost accountant, could be a chartered accountant, so on and so forth. And the next stage is essentially the negotiation. What usually like as discussed by Supallab, what is usually negotiated are the conditions. Say, for example, okay, before I invest, you need to do X, Y, Z. And what would be my rights and obligations? Do I have a right to appoint have a right to appoint the board? Or say 2 directors, 3 directors? Can I appoint an observer on the board? Are there share restrictions? So in case the other shareholders want to transfer their shares, do they have first come to me to sell their shares, or they can directly approach third parties? Can I provide a lock-in on the shares of the promoters, so that they don't sell their shares and they work very hard on the business of the company, right? And there, apart from that, price adjustment that I just explained, and then you have your usual reps and warranties and indemnities. I know this also, we had discussed this at a very high level. Moving on to the transaction documents, and this was very well pointed out by Supallab as well. And these are the usual 4 sort of agreements. Basis the structure that I just discussed can consist of 4 sort of documents: share purchase agreement.
Nabarun, I forgot to touch upon the business transfer agreement and how it is about cherry picking of the assets and then income tax involvement. If you can briefly touch upon that.
Sure. I'll just, I am speaking on the noise. So essentially now the 4 types of documents, right? Okay. So first, let me say what is a better choice for you. Okay. Do you want to buy shares, or do you want to buy asset or, business of the company as a whole? Now, share deals you do usually when, the acquirer or the investor wants to acquire complete control, and it basically provides the seller with a clean break from the business. It is less time consuming, it's less disruption to trade, and it's structurally more simpler. And if the employees of the target are important to retain, there is seamless transfer as no change of employer. And then there's also exit from a company with the premium possible for shareholders. There requires less consents, less government approvals. Now, why would I do an asset deal? Asset deal comes when acquire wants to acquire a bundle of rights and assets and may assume certain liabilities. And you can basically, the other point is that you can basically cherry pick the assets And also helps you to reduce exposure to unknown risks and liabilities. And it's generally to avoid unwanted assets or liabilities. And the due diligence can be less extensive, which is again reduces the cost and time for such transaction. Then there is less transferred liabilities, which may to again less time and less expenditure, and allows the seller to dispose individual assets and undertakings. So a share purchase agreement usually consists of transfer of existing shares, rights and obligations, which would basically vary from shareholding that's been transferred. Then the shareholders agreement usually provides for the conduct of business of the company, the management rights, the information rights, access of promoters rights and companies undertakings, and future fundraise and transfer restrictions. Share subscription agreement usually involves fresh issue of shares by the company, and this is typically a position where company needs more funds to continue their business on run its operations. And finally, the business transfer agreement, which we just discussed, is essentially acquiring an entity or its subsidiary, just buying the business or its assets or part of the business or assets of the selling entity in return for a consideration. And the intention here under a BTA, which is a business transfer agreement, essentially is to acquire only a particular business of a company and not the entire thing.
So basically, when you're doing an asset purchase agreement, the stamp duty implications are higher because the agreement itself acts as a transfer element for assets. It's the long-term capital gains kick in. So generally, investors don't prefer to go for an asset purchase agreement. Business transfer agreements come in when you're buying the business as a whole with assets and liabilities. That is the only difference between a business transfer and an asset purchase agreement. More or less, they are around the same area. But what nowadays people have started doing is they have started doing asset purchase in the guise of a business transfer agreement. So they're actually cherry picking a particular assets, minusing the liabilities, but they're not showing it on paper so that the stamp duty implication is lesser. So understand the nerve of the investor as well as to what his intentions are, and then accordingly advise what kind of transaction documents you should be going forward to.
Just moving on, CPs, closing and post-closing integration. Now, what is really a condition precedent? Now, this is all linked to closing. Now, what is closing? Closing is nothing but the event where the funds or the securities would be transferred. That we consider as the closing, as in the deal is closed. Which when does it ultimately happen? When the business is transferred or the shares are transferred and the funds are transferred. Now, what are CPs? CPs are basically conditions precedent to closing. So all actions that need to be completed prior to closing are CPs, and all actions that can be completed after closing are conditions subsequent. Now, what usually entail in this conditions precedent is basically to comply with, say, regulatory or contractual requirements. So, for example, say that it might so happen that the company that I want to invest in has huge loans. They have taken loans from all banks, HDFC, IDC, etc., etc. So usually, what this loan documents would have is it would usually say that in case you want to change your management or you want to raise further rounds or you want to transfer your shares, you will require my prior consent. And this is basically given in the financing documents that the company and the bank would have entered into. So in order to comply with this contractual requirement, we would basically go to the bank and basically ask them to give us an NOC, which is a no objection certificate, saying that under so financing documents we require your prior consent, and accordingly please give us a no objection to have us raise these funds or let transfer those shares. And the other thing could be, basically government requirements. So there are certain restrictions under the foreign direct investment laws, which, restricts your ability. Say you can only invest, say, 75% of the company. So, for example, in the pharmaceutical sector, there's a cap of 74% that you can basically invest. And beyond that, you need the government approval. So say in one of my transactions, we were basically, advising a foreign investor who wanted to purchase 100% of a very big pharmaceutical company. So we ended up, making the application to RBI saying that, this is why we want to invest, accordingly, please give us permission. And eventually we got the permission and the transaction ultimately completed. So, that those are basically the conditions precedent. Now, closing, as I said, this is the event where the transaction gets closed, the shares are transferred, the business is transferred, and the money comes in. So everybody's happy. It's a good time. Money has come in. The investors got his shares. Now they're investor. So it's a good time. And more often than not, if I'm not confident, right? If I think that the company may kuch, there might be some issues. So I could also have a mechanism where I put in an escrow. So I will have an escrow agent who will keep part of my money or maybe the entire money that I will transfer, subject to there being certain conditions. So eventually, I'll just give an example in one of my deals where we were acquiring basically play schools situated in Bangalore, Bombay, Hyderabad, and we had an escrow mechanism. Basically, the financial statements, what the company had disclosed to us, it was not correct. And after 2 months of the deal, we found out that there was a lot of discrepancies as to what assets the company really had and what they had represented to us. So now, because we had an escrow mechanism involved, we directly deducted the funds from the escrow account. So this is, practical aspects of why we would have an escrow account. Disclosure letter, I think, for the interest of time, I'm just going to skip that. Post-closing integration. This is nothing but, conditions subsequent. So for example, say, there are certain conditions precedents which did not had so much impact. So for example, say the minutes of meetings or the register of members or some, very secretarial items are not in order. And that is not really a deal breaker as such, right? So it just, it's a matter of keeping things at a proper record. So these are usually addressed as a condition subsequent to the transaction. So what we would usually have language in the transaction document saying that, within 30 days of the investor investing, the company would, have addressed all their secretarial issues and appoint a proper, company secretary. The other thing is essentially the filing requirements. So in case the company issues shares to a foreign investor, the law requires you to file a filing called the FCGPR, right? Which needs to be within a certain period after which the money has come or the shares has been issued. So those legal requirements are also addressed as a condition subsequent, right? So these are essentially, what a deal cycle would usually enclose.
It is very important to understand the difference between representation, warranties. When you're doing such kind of transactions, representation, warranties, condition precedent, condition subsequent. When you say it is a condition precedent or a condition subsequent, that means that the deal is dependent on that. So if you don't do it, the deal can technically or very, very legally speaking, the deal can be unwinded because it is a condition precedent. It is not just, and when you're saying it is a covenant, then it becomes less binding. Covenant is basically looking forward once the investment has happened, what the target will be doing, XYZ things. That is not that binding nature. But when it becomes a condition subsequent, that particular post-closing action only becomes very have a huge bearing on the deal. Similarly, representations are are very simpler, but whenever the representation gets backed by indemnity, that means there is a monetary element attached to that representation. If you have misrepresented at any point of time in those representation, then at that point of time, a monetary claim can be made against you. And this is where the disclosure letter comes into the picture, where you disclose and say, ki, okay, I'm giving you the representation, but please know XYZ things are not done by me. Please excuse us on that front. Then your representations become complete. Because if you misrepresent and that is backed by indemnity, and that becomes an warranty, an indemnity claim can be made against you for making false statements in the document.
So representation is usually a representation of the past. So what I would say, see, if I'm a promoter of the company or say I am the company, I would say, I have issued my shares all in order in law. So it's most of a past looking sort of a representation. Warranties is sort of a future looking aspect. So I would say that I will always comply or I'll be compliant with the foreign investment laws. Now there are often lines which a representation and warranty would blur or even overlap, and those cases are more usual than not. So that's representation, warranty, and indemnity as per law is nothing but under Indian Contract Act, it says that it basically saves someone from harm. So in case I misrepresent, as very well pointed out by Supallab, is that in case I misrepresent, that could become indemnity and the company or the promoter could be liable to pay additional amounts. Covenant is basically future looking, and warranty can be both, right? It can be past and it can be sort of future looking as well. It warrants that my company is in all in order and whatever. I mean, as per the representations made or the warranties made by the company, it's basically a negotiated document, and we have warranties. Again, see, if you see this slide on point number 4, warranties can be of 3 kinds. It can be fundamental, it can be business, it can be tax. Now, what are fundamental warranties? It actually goes to the title, or it goes to the very basics of the deal. So in a situation where I am buying the shares of a company, now the fundamental warranty would be what? That the title of the shares is, there is no encumbrance, there are no sort of, there's no lien or something like that. And the fact that the shares that are issued by the company are all in accordance with law, because that is so fundamental, because I am buying the shares ultimately, and if that is not itself in order, then my entire transaction would just fall. So that's why it's called fundamental warranties. Business warranties are such that that my company is compliant with, say, Municipal Corporation Act, the employment laws, stamp duties. All my contracts are duly stamped. I'm compliant with all aspects of Companies Act. I'm compliant with all aspects of SEBI laws. So there's a sort of business warranties that usually companies give, and that depends really on the bargaining power of the parties. In some deals, we have seen companies give. I mean, usually when it's an investor, the big investor coming, so they would have more bargaining power, saying that no, you have to give these warranties. But we have also seen, say, for example, a profitable startup. Forget all these startups, even listed company today are loss making. But some deals that we have seen where the company is actually profitable, they have not given any warranties. Forget fundamental warranties. They have not given any warranties, saying that you want to invest, our company is profitable, you invest, we will not give you any warranties, you take it or leave it. And we had investors basically come and say, no, please take our money, we are more than happy to basically fund your company. So these are all, end of the day, all negotiated points. Now, just on the first point, tag and drag, the right to drag is typically available to a minority shareholder. It basically enables a shareholder to exit the company simultaneously with a partial or complete sale of shares by the majority shareholder. What is the right to drag? This is typically available to a majority shareholder. And what does it do? It enables the shareholder to compel the minority shareholder to sell its stake. ROFO is basically the right of first offer. Now, these are sort of transfer restrictions, we can say, where the shareholder has a right to make the first offer to purchase shares of the party who wants to sell. So if I have a ROFO right, and I understand that the other party wants to sell shares, I will have the first right to make an offer to the person saying, this is my offer. Do you want to sell your shares to me? Now, ROFR. So ROFR is nothing but right of first refusal. It essentially, where the shareholders are selling shares, has the right to obtain a third party quote before approaching the other shareholder. The difference here is that in a ROFR situation, if I'm a shareholder and I want to sell my shares, what I need to do in this case is I need to go to a third party. I will ask, okay, listen, I want to sell my shares. What is your price? How much do you value it? And once I have that number, I have to go to the ROFR holder and I say, this is the offer that I have got. Either you can match it, or you can give me a better offer, or I can sell that shares to the third party. So that is essentially what a ROFR is. Board and management right, of course, it's basically how many number of directors you can appoint. Can you appoint CFOs? Can you appoint KMPs? What about employment? Those things. Reserve matters is nothing but it's a sort of a governance and business conduct, how company can go about. So for example, say if I'm a minority shareholder or a majority shareholder, and I've said that in an event the company wants to amend its articles or issue fresh shares, they would need my prior consent. So I have reserved that matter. In a very layman terms, reserve matters can be understood as veto powers, right? So ultimately, you require my veto. If I'm a reserve matter right holder, you require my veto to do certain business activities or even governance activities of a company, right? So these are the these 5 things are sort of usually highly negotiated and common pitfalls as such in transaction documents.
So ROFO and tag and drag are something which is a typical interview questions when you're doing if you're getting into the corporate practice. So to really in layman's term, say for example, I have this phone and Nabarun has an ROFO on this. Okay. So a ROFO means I will first offer him, Nabarun, I want to sell you this phone for 10 rupees. Will you buy? He will say a yes or a no. If the 10 rupees is unjustifiable to him, the price discovery of the phone is on Nabarun now. He will say whether he wants to buy it at 10 rupees or not. That is ROFO. Okay. I'll not do the price discovery mechanism for him. Then once he says no, I will go and sell it to the other. It's a good right to have. But in a ROFR, okay, the price discovery mechanism is on me. I will go around asking people, tell me the price of this phone. No, what will you buy it for? Say if I put it on eBay, and people, the best quote I get say 20,000. I go to Nabarun and say that I have a quote for 20,000. Will you buy this? Now someone else has done the price discovery mechanism for this and taken the effort to find out what is the value of this phone. And Nabarun will at the last moment will have come and say, okay, I will buy this. That person's right goes for a toss. So it's a good right if you are an investor like Nabarun is in this scenario. If he is a ROFR, he is an investor. It's the best right he's sitting on. But when I have a ROFR, I am the other side of the ROFR. Problem is that people will generally not give me good quotes because knowing very well that Nabarun will come and say, "Ki last moment where I'll buy this one." Chalo. So the entire selling process get a little longer or complicated when the investor is sitting with the ROFO. It's a very good right as an investor. It's a very bad right when you're a promoter. ROFO is comparatively a better right, where there's some obligation on him to also find out the price of the phone. And tag, he has rightly explained, you have the right to tag along. Basically, the name itself explains it. You just tag along. Say the promoter is getting an excellent deal for the shares, for selling the shares to another entity. Okay, and he has only negotiated his own portion of the shares. He's leaving you in the company. You don't want to stay in the company without the promoter. You have the right of tag along. You just basically hook your rope on him, and when he leaves, you also leave. Drag is when you're seeing the company is going down the drain and you don't want this promoter running the company. You basically say, chalo, enough is enough. I will do one thing. I will sell my shares. I will also ensure that you sell your shares. I drag him basically with me. So again, tag is an excellent right when you're both of them actually good rights when you are a investor, but when you are on the other side, these rights are generally detrimental.
So just an overview of foreign investment, how basically how it can be structured. So it can be structured as a foreign direct investment (FDI), which is regulated by non-debt instrument rules and so on and so forth under FEMA. It can also be in a way of foreign portfolio investment, which is under the SEBI regime. FVCI is again also under the SEBI regime, and so are REITs and InvITs. REITs are nothing but real estate investment units and trusts, and InvITs are similarly infrastructure sort of structures that we do. More often than not, it's usually FDI. As you may be aware, India in 2019 experienced about 19 billion USD of inflow of foreign direct investment. So this is probably the hottest thing in the market right now, and every other day you would basically see a newspaper article saying that there's Series A, Series B investment, big entities such as the Tiger Global, Temasek and Axel and so on and so forth, that investing on a day-to-day basis. And the idea is also such that the VCs and the Ps have a lot of money, but the good companies as such are not available. So it's a very lucrative sort of a field that you might be interested in. So this is sort of an overview of foreign investment structures that we deal on a day-to-day basis.
So one more bit is in foreign investment is the ODI. ODI is basically nowadays. See, there was a time when India was more prone to receiving investment, was looking forward to receiving investment. Now things are changing. Now we have homegrown entities which want to go abroad and invest abroad. And I think Paytm is one of a very good example. It has gone and externalized its entire structure. Now it is a Singapore-based company which is reinvesting in India. And if you see, there is a recent amendment and there's a new law which is coming in ODI, which is basically made the ODI structures more fluid. It is good to be aware about that. For example, earlier the ODI had restrictions. It cannot round trip. What I mean by round tripping is that means I sitting in India, invest in a country abroad, and that entity which I form abroad or invest abroad again invests in India. There was an absolute restrictions on that, and there was a subsidiary restrictions as well, where an entity from India investing abroad cannot have a wholly owned subsidiary in India. So these kind of restrictions have now somehow been slightly removed from, and very silently removed in the new regulations. Then there was a restriction in disinvestment, that you cannot just write off your investment abroad and come say that you've lost it. Basically, to stop the outflow of Indian currency in the foreign market. So there were a lot of restrictions. Now those have changed. That is also another aspect of the law which we deal with. Sometimes we deal with a transaction which includes both. So for example, there's an ODI FDI. Matlab, there is an entity which is investing in an entity abroad, and that entity is issuing shares to the Indian entity. It's a swap transaction. So there is an FDI leg where money coming inside India, and there is an ODI leg where money is also coming out of India and going abroad. So that kind of transactions are also there. It's a very interesting arena to be into.
Just to summarize, essentially FDI and ODI are the two flip sides. Foreign direct investment is where foreign investors are coming in and investing. ODI is nothing but overseas direct investment, where Indian entities or Indian individuals are investing outside. So that's the basically a very easy way to remember. Last but not least is essentially the upcoming focus practices, as discussed earlier by Supallab. It's corporate law practice, not just about companies and just company law, Companies Act we're looking at. No, that's not the correct interpretation of, and not the correct way of looking at it. There are few sectors which are coming up, and there are more practices which we haven't, for the interest of time, not put out. But usually you can just see the 8 sort of sectors that I have pointed out is essentially defense, where there are certain FDI linked conditions and other such laws where defense related investments and contracts and all you have to basically look into. And then there's e-commerce and retail. Again, it's FDI sort of linked. Then you have your education, e-commerce, Byju's, all these big companies, they have their own separate regime, and a lot of interesting, there's a new education policy that has come out by the government. All these things are very interesting to look at. Hospitality, basically is the HoReCa sector. Insurance, of course, is regulated by the IRDA, has its own set of laws and own set of instructions and requirements. Pharmaceuticals, again, it's governed by the Drugs and Cosmetics Act and the rules and regulations where they're under the Drug Price Control Act, there's a drug order, there's medical devices rules, so on and so forth. And it's a very lucrative and very niche practice. Fintech is up and coming, as you may be aware that India is one of the leading jurisdiction for fintech, with basis of UPI and NPSI and all those things that we are doing great about it. Last but not the least is ESG, which is nothing but environment, social governance, which is really now a very, very up and coming topic. And we have a lot of law firms specializing into this practice. There are advanced jurisdictions like the US and the UK, which have their own set of regulations and laws looking into the ESG aspect. We have now mutual funds, especially focused on ESG aspects, and they would only invest in companies which have, good ESG rating. And recently, the SEBI laws have also been amended, where disclosure is required to be made and for particular top listed companies in respect to their ESG compliance and status. So, I mean, these are the up and coming and focus sectors.
And before we part, it is also important sometimes before you get into the practice area to understand the terminologies of that particular. There are online booklets available. Corporate law runs on it's a separate set of lingo: pre-man evaluation, then closing, post closing, and there's a very interesting booklet which is there. I think one of the iBanker team has only floated it, which basically deals with all the corporate terminologies of a transaction. So it's better that before you start your career, you in this field of law, you become a little adept to that particular set of language and what it means, because this is something which will help you lifelong. Obviously you cannot miss out on the laws, reading up on the laws, but this is something which will be an added advantage when you know what these terms mean. So when a principal level discussion is happening and they're talking about promote pre-money evaluation, post capitalization structure, and etc., you know what they are talking about. But again, these all draw down and come to that Companies Act, FDI, and ODI, and that's it. It is not very rocket science. The language might be a little high end, but it all boils down to your understanding of the law, and it all fits into those three laws only, those counted
Right.
few laws which in practicing. And second, what I would like to say before a part is that it is very important you super specialize. So right now, for example, Nabarun, he not only does investment transactions, he also does investment transactions which are in pharma sector or in the ESG sector. I not only do investment, I do tech, data privacy, which is and investments in those particular fields. So it has become it has not only grown in length, it has also grown in the width as well. I mean, each practice area has its own spectrum altogether. In mergers also, there are specific categories of merger which is happening. So, for example, there is only tech-driven mergers, and there's a person or a specialist who will only do mergers which are in the tech field. It is that super specialized. So, apart from knowing your bread and butter of companies law and your FMR laws, it is also important you have developed a niche for your own practice the moment you enter into this profession, and you develop your own particular set of skills in that.
I am a practicing advocate in Delhi, and I practice basically in this on the civil side. And what should I be doing if I want to switch over to corporate litigation and take it up? Because I'm not very well versed with company law and all. So how should I go about it, and what time frames am I looking at? Can you please help and guide?
Company litigation, obviously, I have to get in touch with the person who practices company litigation. But I would like to say it is never too late in your life, and company law is not a rocket science. Okay, and if you just pick up the Companies Act and start reading it, you'll understand. And Avatar Singh book can also help you understand the basics of company law. Trust me. And if your basics are clear, no, then nothing can shake you. Just pick up the latest Avatar Singh. It's very lucidly written. I think forget about the authorities. He's the best author when you have to understand the subject. Just pick up his book and read it. Don't try and read the concise version. Pick up the larger one. Okay. Now there are guided courses also, but I have my serious doubts because some of the universities also in the I've seen. I would not go for the names, but in the name of teaching corporate law are teaching something very different. Someone was asked to do a financial. I was telling in the beginning only. Someone asked to do financial diligence. Be careful about what courses you select. But yeah, I think best place to start will be to read up the book before you get into that particular profession. Then once you have done that, the best approach would be to practice under or start practicing under a practicing advocate or who does all these mergers and court-driven corporate litigation. That will be my suggestion to you. And then again, road trajectory is different for different people. You might just help to establish yourself in 1 year, or you might not. You might find it difficult to establish it. I mean, that is completely little bit luck driven also. I mean, as in when you get a job. But yeah, that's how you can start actually. So read up the basics of Companies Act, read up the basics of, and then practice or intern, however, whatever the way you can find yourself into the practice, and then be aggressive about it. And then you will find yourself in that particular profession. Someone has asked, what is the future of labor and employment laws, please? So labor and employment laws again has a huge scope, and it is also ever evolving. It has never stopped evolving. There are always new judgments coming in, new laws coming in. Very soon we'll be having the code of wages and everything fully effective and operational. So there's going to be a huge, although it's been pending for long, but when it comes, it will be a behemoth. And it will cause a lot of disruptions, and people will have to go back to their basics and understand what was the jurisprudence under the previous laws, what were the sections, are the new sections coming into the place. There's a lot of scope. There is advisory. Then in due diligence also, sometimes which are labor intensive acquisitions happening. Well, for example, someone is acquiring a company which is only and only HR driven, say a law firm. It is completely driven by people. So or say the acquisition is happening of another say HR consultancy agencies. Now these are completely labor driven. There is hardly any other asset involved, and a specialist labor team has to be involved. Or say an entities like Ola and Uber, how they treat their employees is something which is on a very fine balance of employees and consultants, and freelancers. So this is where the labor law specialists come in and say, give their opinion that what will be the categorized on this. There's a lot of scope, trust me. If it is well known even within the law firm that you're working in, that you are a specialist in labor laws, and people need some expert opinion with every now and then about how the labor thing should be structured. There is actually a lot of scope, and very few people practice it. Once you're through and you have gained an expertise on this, nothing like that. Again, start with the basics, read up on case laws, keep on reading, and you'll become a specialist. It's as simple as that.
Why risk advisory important in merger and acquisition?
See, that's why we do the diligence, right? If I've got the question right, that is the reason why we do the diligence. Because unless you do the risk assessment, you take up something and then you sit with then you're sitting on a time bomb basically. So for example, let me take as simple examples of EPF ESIC. Now I know a promoter who had shut down an entity long time ago which was EPF non-compliant. The EPF entities came and locked the bank account of the new entity which has investors sitting on it. Now imagine a situation where an investor and the operational bank accounts of your particular and your operational bank account is only seized by the EPF. You don't know where it will be released. The entire operations of the company is jeopardized.
I'll just add to that. So, I gave an example earlier where we had fertility clinic, and we were doing a diligence at that point when we were doing a Series B funding. So they were already a $50 million or had already been invested, and suddenly one day we find out that the entire business model was illegal. So all the investors had literally lost all the money that they invested. Similarly, another transaction. So there are a lot of types of due diligence, right? Risk analysis. So there's a tax due diligence, there's financial due diligence, and then there is legal due diligence. So in this particular company that we were doing, the promoters had actually some 80 crore worth of debt, and he was, basically there are a lot of courts and a lot of proceedings going against him. And ultimately our investor decided not to invest in it. So what usually the point here is, so today if I invest say $100 million, and tomorrow I find out the company doesn't have basic license, so all my money will go to waste. So therefore it's imperative, and every transaction that you would see, it always involves an element of due diligence. Nobody wants to invest high stakes without actually knowing the business, actually knowing what this company is doing, whether they're legal or they're whether it's as per the laws or not. So it's absolutely crucial that the due diligence must be done and risk be analyzed. So it's unsaid that it's always done.
Even if it is not about just basic law, licenses are missing, it can get very, very technical. So for example, as I was telling you, under ODI, you could not round trip. You cannot send your money outside and get it back to India through a subsidiary. Many law firms also started doing this. They advise people, someone asked someone to set up a company abroad, and this cannot happen at the same time. You can invest abroad, but you cannot have the investment in India level also, at US level also, and back to India level at the same time. So what they used to do to structure it, they used to ask someone to incorporate a company abroad and gift the shares to this Indian guy. AD banks, when they started finding out about this, they asked them to wrap up the entity abroad. So imagine you have taken your entire operations abroad. Some investors has actually invested abroad in that particular entity. Now the AD bank, RBI, and the AD bank is basically the arm of the Reserve Bank of India, ask you to wind that entity up and get everything back to India. Now imagine the situation if you have done a merger with an entity like this, or entered into any sort of transaction with that entity. It's gone.
Interestingly, now that you pointed out, so there is a recent order of the RBI, not recent, it's quite old. They basically asked the entire transaction to be unfolded. So whatever you have done, whatever investment, you basically, just undo it. So, basically, even if regulators come after you, especially the RBI, your investment is gone. So nobody wants that risk.
Competition law for that matter, if you don't do a proper merger, proper competition law analysis of your deal, they will ask you, keep us unwind, sell your assets. There are entities who have been asked to sell their assets. They cannot operate in all part of India with same volume, because they had become a mammoth in terms of size. They had to divest. This is what it entails in risk management. If you don't do this basic diligence, then you are putting your investor at risk or your client at risk.
My question is what is the difference between preemptive rights, ROFO, and ROFR?
Preemptive right, these are very typical to an investment transaction. First of all, to give you a brief overview, preemptive right is basically your right to subscribe to more shares. Okay, so for example, today an entity is looking for funding, okay, and it takes money from you, but subsequently keeps on adding other people in the EA. What happens is your shareholding gets diluted because you, as on date, your holdings at 20%. But as and when more investors keep coming in, your 20% will get reduced to 15 to 13. And there will be a point of time when you will have no say in terms of voting rights in the company because of the minimal number of shareholding that you hold. What preemptive right secures is basically your right to subscribe to more shares so that you can maintain your particular shareholding. Anti-dilution is basically when the promoters act funny and say they have issued you today one share for 20 rupees. Now they are not getting substantial investment. Next round, they are selling that same shares, same category of shares or a different category of shares, but at a lower valuation. A same category of shares at a lower valuation, not a different category. Same category of shares at a lower valuation. Or a subsequent fundings are happening at a lower valuation. Say one shares are getting issued at 10 rupees or 5 rupees. What is happening is you get only 10 shares for say 20 rupees. You invested 200 rupees and you get 10 shares for 20 rupees. And your shareholding is that much, but people are paying as low as 5 rupees and are getting more number of shares and more voting rights. Your rights get prejudiced, right? So what an anti-dilution clause does is basically protects your interest and asks the the clause asks the promoters or the company to issue you the equal number of shares which you should have got had you got the shares for a lower valuation. So instead of getting for 200 rupees, instead of getting 10 shares, now you get per share for 5 rupees. So you get additional shares subscribed to you as soon as possible. That is anti-dilution. ROFO is, as I explained in layman's terms, is basically I have something to sell and I have to, and say Nabarun over here is sitting with a ROFO right. I will first offer him, say XYZ, I don't know the price. You tell me, will you buy it for that price? He says, okay, I'll buy it for 20 rupees. And I am satisfied with that. I sell it to him. That is a different story. But I'm not satisfied. And I don't think this is value is 20 rupees. It is much more than that. I go around in the market asking for people. I get a better price. But he has the first right to know that I'm selling it. Okay. ROFR, on the other hand, is basically, he's there. I go around asking people that, listen, I want to sell this, listen, I want to sell this, listen, I want to sell this. Everyone gives a price. So someone says 15 rupees, someone says 25 rupees, and see, best price I get for that particular pen is 25 rupees. I'll come and tell Nabarun, I'm getting a price of 25 rupees. Nabarun will think, boss, this is the best option. Let me just buy it. He pays me 25 rupees. But what happens is, when I have a ROFR, when I'm sitting on a ROFR, I go around for a price discovery. No one will give me a good price because they know very well that Nabarun is sitting there to buy it. Why will they take the effort of finding the price for you? Why will they go and do a diligence behind the pen, whether the pen works properly or not, whether it is worth 25 rupees or not? So that is what's basically ROFO and ROFR.
Anti-dilution and your preemption rights are in context of issuance of new shares. Now, preemption rights, of course, if a company offers to issue new shares, they should go to the existing shareholders. And why this is there? To, like as rightly pointed out, Supallab, to maintain my shareholding. So suddenly I don't want, if the company wants money and I'm the existing investor, you come to the existing investor, you ask me for money, I will be more than happy to help. If I don't, then you go to someone else. That's the preemption right. Anti-dilution, now I'll just put in a technical word, anti-dilution only occurs when there's a down round. And as rightly pointed out by Supallab, down round is nothing where the issuance price, the subsequent issuance price is lesser than the prior issuance price, right? So today I was issued, say 10 rupees ka share. Tomorrow company is issuing it 5 rupees. So that's a down round. And in order me to maintain my shareholding and so that it's not unjustified to me, some protection mechanism will be there. And now there are three ways of dealing with anti-dilution, which is a full ratchet and broad-based and all those things. But we'll not get into the details of that. So preemption and anti-dilution are in context of issuance. ROFO and ROFR are in context of transfers. So there is no issuance happening. If a shareholder wants to transfer, then the ROFO will get triggered. And preemption and anti-dilution is only case of issuance. So that is primarily the broad difference that is between those four concepts. That's just I wanted to point it that out.
Will doing LLM in corporate governance will give any added advantage in practicing in the field of corporate law litigation?
No.
Yeah,
it's a very big no.
So usually why we do LLMs is, of course, you learn more and stuff, but it's also because of the networking aspects of it. So if I go to a prestigious university, say Yale, Cornell, Harvard, I will meet, say, for example, other lawyers who are equally great in, say, and eventually I would understand that people like them would become probably a general counsel at a Fortune 500 company or become a partner in a big law firm. So in a big diligence or in a big matters which involves Indian entities, I will have, because I know that person and he knows me, I will have an opportunity of directly working on those deals. So it's more about networking, in
the actual knowledge. But having said that, if you grow your skills properly while staying in the profession and learning on the profession, that is equally helpful. And networking helps to an extent, but at the end of the day, there are other executive MBAs and everything that for that you need not get, like, just for the heck of networking, it's not worth wasting a year in and not getting into the profession, because the faster you get in the profession, the more you learn on the job. And there is no substitute in when it comes to being a lawyer, there's no substitute than learning on the job. And do not stop reading. That's it.
The other important aspect is really, so for example, if I'm doing a master's in the United States, and tomorrow if I have investors from the United States, they will have more comfort working with me because I will have more knowledge at a given point than of the US laws applicable and how it will interplay with the Indian laws. That's a sort of an advantage which all the foreign clients see. Because tomorrow, if I have a UK degree and I have a UK investor coming, he will be more comfortable because he will be like, okay, this person would know general applicable laws and how things work in the UK. So that's another added benefit. So of course, LLM, of course, it does help. But given if you're doing Indian transactions and you're only working with say Indian companies and so on and so forth, it's not really relevant. But in those situations, as I previously discussed, networking and giving comfort to the foreign clients, that is really where it comes in. And that is sort of over a holistic knowledge also that you will have. So that is definitely an advantage, to say the least.
And be savvy about where you're getting from where you're getting educated from, because most of the professors, at least in India, corporate law LLMs, most of the professors don't have on-hand experience of working in a corporate field. And even if, just be careful about what you're venturing into and don't end up, you go abroad and learn it, like Nabarun rightly pointed out, that's a different ballgame altogether. But that particular advantage will not be any use if you are doing it in India. You have to be very careful about what you're getting taught, what is the curriculum, because again, what they teach and what is in practices are not full and south full.